Then there are two other judges, and we're going to them now. Let's begin with Agnes Dodzi, who says, and her arguments, the arguments of Agnes Dodzi and Justice Adom-Otchere are quite simple. So they are saying that, yes, the High Court has given an order. Mr. Justice Quayson is violating the order. The High Court itself must ensure that he complies with the order because he ought to comply. The Supreme Court cannot come and enforce the order. The High Court must do it himself. That is all. That's what a dissenting opinion means. Let's have a look at it. This is Agnes Dodzi, JSC, writing her judgment in the document. It says, and we picked it from somewhere in the middle so that it's clear. He says, it is clear from the wording of the above rule that the grant or refusal of an application for interlocutory injunction is at the discretion of the court. The courts over the years have developed their own guiding principles in the exercise of this discretion. She goes on, some of the recent decisions of this court which have outlined the state of the law on these guiding principles are the cases of Wilford. She names them, and she names the cases. Okay, let's move on. In the case of Wilford Kwaku, she says that a bad JSC numbered these principles at page 260 as follows, quote, it has always been my understanding that the requirement for the grant of an interlocutory injunction first, that the applicant must establish that there is a serious question to be tried. Secondly, that he or she will suffer irreparable damage which cannot be remedied by the award of damages unless the interlocutory injunction is granted. And finally, that the balance of convenience is in favor of granting him or her the interlocutory. It is my view, Dodzi continues after quoting that Adom-Otchere. She says, it is my view that filing this application in this court is not the remedy open to the applicant. The remedy open to him is the execution of the judgment of the High Court. For the violation of the orders of the High Court, nothing prevents the applicants from seeking redress in that forum by instituting contempt proceedings against the first defendant respondent, which is Quayson. So that's the point Agnes Dodzi is making. She says that forget about Justice Kulendi. We don't need to entertain this interlocutory application. It's our discretion to decide to entertain or not. I think we should entertain it. The High Court has given a ruling. Somebody is violating it. The applicant knows what to do. Go to the High Court and tell them that somebody is violating and put out a suit for contempt. And let Mr. Quayson be found for contempt, and he may be in prison for 30 days. He will not be in Parliament at that time, and then you can deal with it. That's what Agnes Dodzi is saying. That if there's a clear and very obvious unchallenged violation of a High Court ruling, which is bizarre for a member of Parliament or a would-be member of Parliament to be violating a High Court ruling knowingly, and worst of all, being supported by a group of people to do so, that's terrible, isn't it? Okay, so she's saying that if that happens, you don't need the Supreme Court to do anything. The High Court can deal with it. Okay, she goes on. It is pertinent to note that the orders of the High Court made in this judgment virtually addressed and determined almost all the prayers of the applicant in the writs generating this application. I have outlined the orders of the High Court as beginning of this ruling, as well as the prayers in it before. Reading the orders of the High Court alongside the prayers in the writs before us demonstrates that the decision of the High Court had determined the issues that may arise for determination of the suit before us. Okay, it is trite that the High Court has no jurisdiction to interpret the Constitution. But the question is, in view of the High Court decision exhibited as MAN 2, is there any need for the interpretation of Article 94(2)(a) of the Constitution? In my view, there is no serious question to be tried by this court if this court should interpret the said article at all. I consider it an academic exercise. That's the point I was making. The point I was making is that the matter before the court is just merely an academic exercise. It's not going to change anything. That's what Agnes Dodzi is saying in her dissenting opinion, that the matters of interpretation, the heavy, weighty matters, have already been settled by the High Court. And as I said, it's a simple matter in this case. Date. What date did you file? At that date, were you Canadian, Ghanaian, Ghanaian, Canadian, Ghanaian only, Canadian only? It's straightforward. It's a matter of documents. You can check and find out. So what she's saying is that the matter of interpretation of Article 94 has already been done by the High Court. It's been done very well. She doesn't even think the Supreme Court should look at it. On the basis of that, she says the Supreme Court ought not to have entertained the application for an interlocutory injunction just to enforce the High Court's ruling. That's what Agnes Dodzi is saying. And then Adom-Otchere is saying that with her. Okay, let's move on. I hold, therefore, that the applicant has failed to establish that there is a serious question before us to be tried. On the question of injury to the applicant or balance of convenience, if the plaintiff applicant ever suffered any injury or inconvenience at all, he had been given remedy since 28 July 2021, when the High Court delivered its judgment in exhibits so and so and so, which perpetually restrained Mr. Quayson from holding himself out as a member of Parliament. Applicants concerned applicant's concern should be the enforcement of the judgment he obtained from the High Court several months ago. In the circumstances, it is my view that the applicant has not made out a case for the grant of interlocutory injunction. The application lacks merit, and I will therefore dismiss it. Okay, that's interesting. Agnes Dodzi says, you have a ruling of the High Court. They said that Quayson is not qualified. So just go and enforce it. If he doesn't like it, go and file a contempt against him. The Supreme Court need not do it. Justice Kulendi says it's a constitutional matter. And any violation of a constitution by any person, the Supreme Court ought to be interested in it, because Supreme Court should be the bulwark, the pivot, to drive the constitutional process. And so any violation of the Constitution should be seen by the Supreme Court as a violation of everything. And it's a matter that concerns all Ghanaians. So the Supreme Court cannot sit aloof and say that we'll dismiss the application on the basis that the High Court can enforce it. Here is a violation of the Constitution. And so the Supreme Court must come in. That's the point Justice Kulendi makes. And it's against the point that Agnes Dodzi and Nena Megache make in their dissenting opinion. Here's a bit of Nena Megache's ruling. He says that there is no dispute about the fact that a petition under the Representation of the People's Act was filed to challenge the validity of the election of the first respondent as the parliamentary candidate for the Asin North constituency. There is also no dispute that the High Court Cape Coast delivered a judgment on the 28th of July and declared that Mr. Quayson's election was null and void and restrained him from holding himself out as a member of parliament. He goes on, there is further no doubt that the first respondent, Mr. Quayson, appealed against the judgment of the Court of Appeal to the Court of Appeal Cape Coast, which by the decision of this court in re-parliamentary elections, Wolensi, Zakaria, etc., is the final court of appeal in election petitions brought to challenge the validity of the election. Okay, a breach of the order of the injunction issued by the High Court should have been enforced at the High Court or the Court of Appeal, as the case may be. It seems to me that by the grounds stated in the affidavit in support of the motion for an interlocutory injunction in this court, all that was urged on us is the breach of the injunction order issued by the High Court. In my view, it is not the responsibility of the Supreme Court to enforce orders of a lower court, which are breached unless the matter is on appeal before it, and it is seized of the matter. Even if we were to accept the argument of the applicant that the present application is founded on the writ, its determination will prejudice the outcome of the writ in the sense that ultimate outcome of the writ is what the application is seeking from this court to grant him in the interim. I don't quite understand that, but let's continue. In my view, where the outcome of an interlocutory application will prejudice one way or the other the matter of a substantive application, a court must be firm in exercising its case management powers and fix an early date for the expeditious hearing of the substantive application. Such a directive will dispose of the interlocutory and substantive application hearing. Okay, the only exception in my view is where there was likely to be irreparable damage or loss outlined in the case of Kwame and Kwame Pianim. That's one of my favorite cases. In this case, the first respondent, Mr. Quayson, had been in Parliament from 7 January. Okay, Nena Megache, we have to cut it off at some point. Yes, but that's Nena Megache's view of the matter. Completely agrees with Agnes Dodzi, so the two of them are on the same page. So tomorrow when you hear people say the Supreme Court decision in Asin North was a 5-2 and the 5 judges said that he should leave the parliament and 2 said he should stay, that's not correct. All 7 judges think he should leave the parliament. He was ineligible for the election and he's going to face prosecution. So that's the story.